Chicago's Morning Answer with Dan and Amy continues now, and make sure to stay tuned to catch me, Mike Gallagher, coming up at 9, only on AM 560, The Answer.
Good morning, Dan and Amy. When these controversies over same-sex marriages, same-sex ceremonies arose several years back, about the time of the Masterpiece Cake Shop case in 2012 in Denver, Steven Crowder of Jesse Waters. Are they the same person? They seem like it to me.
You know what? That's
Steven Crowder did a little experiment. He went to a number of Muslim-owned bakeries in Dearborn, Michigan, and asked the same question or made the same demand that was made of Jack Phillips at Masterpiece Cake Shop in Denver. And here's how that went.
What's really important is getting the picture and the writing. So it's going to be me and Benny. Well, you have pictures there.
No, on the machine you have in Kroger kitchen.
In Kroger?
Yeah.
Like the grocery store?
No.
Where you would tell me to go somewhere across the street. And I wanted to say Ben and Steven forever on the top. And then on the bottom, it'll say, same-sex, legal now, congratulations. But everyone keeps sending me somewhere else. They said, this is what you do here.
No, I don't want it.
It just seems weird that you send me Oh, I don't, okay, well, let's even say no picture, but you can write on it, Ben loves Steven forever, and have our hands maybe holding.
No.
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 So, ultimately, some of the Muslim-owned bakeries, cake shops, agreed to do the cake, and some did not.
Okay.
In 2015, a Christian activist named Bill Jack walked into 3 separate bakeries, one an erotic-themed shop, and asked for each to design a cake in the shape of a Bible. One side saying, God hates sin, with the citation, Psalms 45:7. The other, homosexuality is a detestable sin, from Leviticus. On another cake, Jack requested that the bakery inscribe a Bible verse on one side, while we were yet sinners, Christ died for us, Romans 5:8. On the other side, God loves sinners. In all instances, the proprietors refused to take the project, refused to bake the cakes. And as David Harsanyi writes in The Federalist, and why should any American be forced to create something that clashes against their conscience? And isn't that the point in the Masterpiece Cake Shop v. Colorado Civil Rights Commission case? Jack Phillips, on the occasion of his victory yesterday, penned an op-ed for the USA Today, saying, writing, as a cake artist who owns my shop, I've always been willing to serve everyone who walks through my doors, but it doesn't mean that I create every cake requested of me. And he goes on to say, if I'm asked to design a cake that celebrates an event or expresses a message in conflict with my faith, I'm obliged as a matter of conscience to decline, but I still offer those customers anything else in my shop and tell them that I gladly create them a cake for a different occasion, which is exactly what he did for the 2 gentlemen who demanded he make a cake for their same-sex wedding. I can't do that, but I can sell you brownies, I can do this, I can do that. Not good enough, because they were, looking to use Jack Phillips as an example. This is politicized from the start, of course. People say, just make the cake. Just make it. What's the big deal? Just make the cake. To that, Jack Phillips responds, those folks fail to understand that as an artist, I pour my heart into my wedding cakes, and that my conscience will not allow me to celebrate something in direct conflict with my faith. And the other thing he said, writes about, in addition to losing 40% of his business and facing death threats because he dares to disagree, he dares to abide his faith tradition. This is an interesting perspective he offers. The Colorado Civil Rights Commission, the government, ordered me not only to stop doing the wedding work I love, but also to teach my remaining employees, all of whom are my family members, that I was wrong to operate my shop consistent with my faith. In other words, the state told me to tell my mother that the faith she taught me has no business influencing my life. The state telling me I'm wrong in terms of how I operate my shop and to live my life according to my faith. Remarkable. And by the way, Clarence Thomas warned that these such cases would come to pass after the Obergefell decision, that same-sex marriage was going to run headlong into religious liberty, and it has. And in this case, to be clear, the Supreme Court found the Colorado Civil Rights Commission's conduct to be bigoted and essentially beyond the pale, but they focused on the Civil Rights Commission's conduct. They didn't make a broader statement about religious liberty protections under the First Amendment, and thus the 7-2 kind of walk-away decision. For more on this topic, we're pleased to be joined by Georgetown law professor and author of Our Republican Constitution, Securing the Liberty and Sovereignty of We the People. He is Randy Barnett. Randy, thanks for joining us. Appreciate it.
It's great to be here, Dan and Amy, and I'm hungry. I want some cake.
Yes. Well, that depends what the message is on your cake. So, what
every time I hear about the cake shop cake, I taste of all these delicious cakes.
Yes, salivating.
It makes me want a cake.
Right, of course. Well, Jack Phillips is up and running. So, what about the import of this case, given its sort of narrow holding that really pertains to Jack Phillips and maybe not a lot more?
Yeah, it's a very narrow holding because, and this was telegraphed in oral argument. I think I mentioned to you on your program right after oral argument. Mm-hmm. It's a narrow holding based on the animosity or animus that was manifested by some of the commissioners who were deciding Jack Phillips' case. And this was actually something that came up a lot in oral argument. Justice Kennedy expressed his concern about that, and then immediately after that, Justices Alito and Gorsuch underscored that by other evidence in the record that showed this animosity. And that ultimately is how the case came out. So if there's another case where the government shows this kind of animosity in the future, then that's covered by this one. If the government is more careful and cautious and doesn't say the things that these commissioners said about religion, then Challenger is going to have a much harder time. And this case will be of limited help. Not of no help necessarily, but of limited help.
So what does this mean for, owners of small businesses? Say if you're a photographer or a florist or a makeup artist or a hairstylist and you don't want to take part in a same-sex wedding, are they protected in any way because of this ruling?
I would say they're not really protected by this ruling yet, but there hasn't been an adverse Supreme Court ruling to theirs. In other words, they're not protected by this ruling, but the court has not ruled against them either. That might happen in a future case, but I would probably advise them to just tell the customer that they are fully booked up and they're busy. If they start citing their religious objections, they may very well find themselves in Jack Phillips's position, and then at that point they're going to be in a protracted lawsuit.
Justice Anthony Kennedy, of course, who wrote the majority opinion in Obergefell, which was literally an opinion, like an op-ed, not a legal document, continues with his op-ed writing, in this case saying, recognizing that these disputes must be resolved with tolerance, without undue respect to sincere religious beliefs, and without subjecting gay persons to indignities when they seek goods and services in an open market. That's not much of a legal standard. That requires a lot of Solomonic decision-making on a case-by-case basis, doesn't it?
Yeah, but that itself doesn't make it objectionable if, in fact, the Constitution is limited to protecting persons from intentional discrimination. You have to examine the motives for a particular ruling. We have that in our anti-discrimination laws generally. Employers are only held guilty of discrimination if they adopt a test, but they do so intended to restrict people on the basis of race, even if they don't say so. The courts will inquire into intent, and that's essentially what Justice Kennedy is doing here. He did a similar thing in the Hialeah case, in which there was a law passed that banned the sacrifice of animals. Why? Because one particular religion was doing it, and he saw that there was evidence in the record that showed that this law was aimed at them. It had animus towards that religion. He said that's barred by the First Amendment.
The problem, it seems to me, though, and Clarence Thomas touched on this in his dissent in Obergefell, is, and I'll just borrow from Justice Thomas's words, the decision rejects the idea, captured in the Declaration of Independence, that human dignity is innate, and suggests instead that it comes from the government. This distortion of our Constitution not only ignores the text, it inverts the relationship between the individual and the state in our republic. Do you agree with that?
Well, I agree with that statement that Justice Thomas made about dignity isn't given by government. It's something one has, and government can't take it away. It doesn't really help us in this case very much. This case was about whether a law of general application, which is an anti-discrimination law, would apply to Jack Phillips, or whether the First Amendment, free exercise of religion, or freedom of speech provisions would somehow exempt him. It did protect him up to a point. It protected him from explicit animosity towards religion. That's not nothing. And there are possibly other cases like the Arlene Flower case, which is going to also have evidence of such biases. But if government is cautious and doesn't express these opinions, a challenger is going to have a much harder row to hoe. And this case isn't going to help them. They're going to have to appeal their own case to a court that might have a different makeup by the time a case like that got to the court.
Well, right, yeah, and so the question is, what kind of case? I guess the fact pattern of a case where the Supreme Court could establish a precedent in these matters that has a broader application. I mean, so if the Colorado Civil Rights Commission had been polite rather than kind of openly and bigotedly hostile to Jack Phillips, the case could have turned out differently, and that would have had perhaps more sweeping implications in terms of restricting religious liberty.
Yes, it could have turned out differently, but because that case wasn't before the court, we can't be 100% sure that it would turn out differently. Justice Gorsuch argued why it shouldn't turn out differently, in part because regardless of what their statements were, the Commission and the Court of Appeals treated other examples of bakers refusing to deliver cakes they thought were offensive differently than this cake. And so that differential treatment was also problematic, according to Justice Gorsuch. So the point is we just don't have an opinion on the ultimate issue. But I think supporters of free exercise of religion are going to be satisfied or happy to take this half a loaf or half a cake, we should say, because half a cake is better than no cake at all, which is what would have happened if it had come out the other way.
So it was a 7-2 decision.
We should also, you asked that question because that's where I was going next.
Yes, and have ice cream with your cake. 7-2 decision. I mean, Ruth Bader Ginsburg and Sonia Sotomayor are the only two that dissented. Is this some ray of hope when these cases come up before the Supreme Court in the future?
It suggests that Justice Kagan and Justice Breyer, who actually not just concurred, they joined Justice Kennedy's opinion, making it a 7-2 opinion, agreed that local governments cannot express animosity towards religion, and if they rule based on that animosity, that's unconstitutional under the First Amendment, even though the law they were enforcing was general. So that's a good thing that we have a 7-2 decision like that. It takes away some of the political valence against this decision, but it doesn't get us all the way. And Justice Kagan, in her concurring opinion, explains that as long as there's no expressed animosity, then the case would have come out differently as far as she's concerned.
An interesting response from one representative of the other viewpoint is this Jennifer Finney Boylan op-ed in the New York Times. She's apparently an academic at Barnard College and also a trans woman. She suggests something that the president and chief executive of GLAAD, which is a gay rights group, has proposed, which is the Dignity Amendment. The Dignity Amendment to the Constitution: equality of rights under the law shall not be abridged by the United States by any state on account of sex, sexual orientation, or gender identity, quote unquote. The Dignity Amendment. Do we need a dignity? I mean, need, I guess, is perhaps the wrong way to say it. But is there anything in the proposed Dignity Amendment that isn't covered by the 14th Amendment?
Well, I really haven't I haven't read the amendment. I really don't know what it says, and I haven't given it any thought. So I tend to decline to answer questions, counsel, until I have had a chance to reflect on it a little bit longer.
So be that way.
But I mean, it's more of a general statement of principle, though, that the 5th and 14th Amendments guarantee equal protection of the law for all Americans, regardless of their race, gender, orientation, and the like, right?
Look, I think the due process clause, which really ought to be called the due process of law clause, in both the Fifth Amendment and the 14th Amendment, protects citizens from arbitrary rule.
Mm-hmm.
That is, rule that's based on no reason at all, or a reason that's bad reason, a reason that's not within Congress's power or the state's power to legislate. So, yeah, I think that the 14th Amendment already protects individuals, same-sex individuals and other individuals, against arbitrary or irrational discrimination. That's my reading of the 14th Amendment, and we don't need another amendment to say that any better.
He is Randy Barnett, Georgetown law professor, by way of Chicago, I'll add, and author of the book, Our Republican Constitution, Securing the Liberty and Sovereignty of We the People. Professor Barnett, thanks as always for joining us. Appreciate it.
I always usually add that I grew up in Calumet City, right across the border from Indiana, and so I have to throw that in there again this time.
All right, Cal City, Sin City.
I know. Well, I was going to just say Cal City, not Sin
All
City.
right. Now that Randy's left, it's no longer Sin City. Thanks, Randy. Appreciate it.
Bye.
You've joined us on our turnkey.pro